All right, let's break this down right now with civil rights attorney Sanford Rubenstein. Mr. Rubenstein, great to see you again here on Law and Crime.
Thank you for having me.
Okay, so what we see here is a really interesting witness. She's saying Laquan McDonald didn't appear to be an attacker. I was right there. But when you read David March's report, one of the defendants, her statement was that Laquan McDonald lunged and tried to attack Van Dyke. How do you reconcile that?
Dora Fontaine clearly is the hero in this case. Her testimony, combined with the pictures of the truth, the video from the first trial, which has been shown in this trial as well, clearly indicates that what happened here is not what was reported in the report, and in fact, that report was an attempt to cover up this wrongful killing.
And I want to talk a little bit more about what the defense tries to do to discredit her, but let's play a little bit more of her testimony and we'll break it down. So, Mr. Rubenstein, you called her the hero of this case, but when the defense had a chance to cross-examine her, they called her, I want to make sure, they basically accused her of being a lazy police officer who lied under oath basically to save her job because she said one thing at one point and now is denying it here today. What would you say to that?
What else can they try to do to try to impeach her credibility? There's a video which shows pictures of the truth, what actually happened here. What was reported in the police report, allegedly what she said, was not true. She never said it. That's crucial here. I don't see how that cross-examination undermines the credibility of what she's saying here.
But couldn't the counter-argument be what we keep seeing is a conversation about, there seemed to be confusion that night about whether or not this was a homicide, whether or not it was an aggravated assault. I'm talking about when it first happened. And the question is, maybe initially she thought that he appeared to be more of an attacker and appeared to be a threat to her fellow officers, and only now, after Jason Van Dyke was up on trial, and now that these three officers are up on trial, she changed her tune.
If we didn't have the video, perhaps that kind of cross-examination and that kind of attack of her credibility might work. But we have the video. That combined with her testimony, I did not say that. She's clear about that. And she was outraged when she found out it was in the report. I think this trial, with a judge as well as the determiner of the fact, as well as the law, because there's no jury here, it's a judge-only trial, this judge will see clearly the actual credibility that this witness has.
Let's talk about that. So there's no jury here, right? The way that you argue in front of a judge, is it different than the way you argue in front of a jury? Because one of the things that we saw was such an impassioned plea from David March's attorney in the opening statement, almost as if he was speaking to a jury to convince them one way or another, but you're speaking to a judge. You're arguing in front of a judge. How's that different?
I would suggest the whole strategy of a trial is different. In a jury trial, you might want to emphasize the innocence of the police officer as well, to try to show this jury, even though they probably know there was the innocence of the police officer, they know there was a conviction. But you may want to try to show that, not because to try to influence the jury's determination with regard to the cover-up issue. There are two different issues here. But there was a conviction in that case. So while a jury may find the underlying facts as presented by defense lawyers in the underlying case something that might influence their determination in this conspiracy case, this cover-up case, it's not going to happen with a judge.
Okay. Well, we got a lot more to dissect. I'm glad you're here. Let's take a quick break, and we'll be right back. Okay, let's break this down right now with Sanford Rubenstein. So this back and forth about whether or not his report is accurate, whether or not he actually spoke to David March, and whether or not David March actually made this statement that Laquan McDonald lunged at Van Dyke. What do you make of all that?
Well, let's look clearly at what his role was, Marsh's role. Marsh's role was as a recorder of the facts based on the officers that were on the scene. One of the officers on the scene, who I've called the hero, Dora Fontaine, never made the statement that March put in the report that he made that he saw the victim lunge. This doesn't change that.
And the idea that maybe he didn't speak to David March, I don't mean to laugh, but the idea that questioning whether or not he actually spoke to him and trying to analyze the phone system, is that an effective defense strategy?
That's grasping for straws. They've got nothing else. So they grasp for straws and try to use anything they can to impeach a witness. I don't think it's going to work here.
When we talk about reasonable doubt, though, is it not possible that people, officers, if we're already accusing the police department of doing improper reporting and trying to do a cover-up, is it not so improbable to think that when the shooting happened, officers or officials were saying one thing, and then when Van Dyke got charged, and now these three officers got charged, they switched their stories?
Look, reasonable doubt does not mean any doubt. So reasonable doubt would be the only way, I think, that any success would be in the defense here. Now, you have a judge-only trial, a judge who was a former prosecutor. I don't see this judge buying it. This case will turn on the fact that Dora Fontaine testified that what was in the report put there by one of the defendants, Marsh, was not what she said. Clearly an attempt to cover up what happened.
So you think, I mean, again, they're charged with conspiracy, obstruction of justice, and official misconduct. The conspiracy charge is not as difficult to prove as some people might believe in this case. It seems pretty straightforward to you?
Well, the conspiracy charge would mean that they spoke amongst themselves, the officers, to figure out a way to try to get out from what they saw coming, which would be a criminal charge against them.
But can you base it just on circumstantial evidence? Hey, there's similarities in language in their reports. It contained false information, because the counter-argument is it's sloppy police work. Maybe they didn't do a thorough enough job, but were they really trying to cover something up?
That's a question of fact for the judge to make a determination with regard to. And again, as a former prosecutor, now sitting as a judge, she is not going to be influenced by the stuff that really doesn't matter.
Right.
And I think she's going to look at the hard evidence. Once again, this video, pictures of the truth. And that video was confirmed by Dora Fontaine.
Right.
So they've got a case I think the prosecutors wrapped up.
Dora Fontaine was a very important witness, but when we come back from our break, we're going to play the testimony of Jose Torres, a really, really impactful witness from last week. We'll be right back. Okay, so this is interesting. The idea that he had no dog in this fight, was just living his life, sees this guy gunned down, and yet he sees on the news this idea of lunging never really happened, and he stepped forward. What do you think about that?
He is an eyewitness to what actually happened here. He's a hero also. An eyewitness, disinterested in the outcome, and he does what a good citizen should do. He comes forward to say what the police are reporting happened did not happen that way. So we have the video from the dash cam, which shows that there was no lunging. We have Dora Fontaine, the police officer, who swears under oath that she never told Marsh, who was the recording officer, that there was lunging, yet he reported that in his report, that that's what she said. Now we have an eyewitness who said there was no lunging. These defendants are in big trouble.
Well, let's see what the defense attorney for David March did under cross-examination of this witness. And if you haven't seen it, you really should. Take a look. Okay, so what do you think? Maybe some effective cross-examination there. He didn't see everything everybody else did.
This is a perfect example of when you ask some questions and you don't know what the answer is going to be, you may get an answer you don't want. He clearly said, I had a clear view. So does it matter whether he was looking out of the front window or the side window? The purpose of this cross-examination is to try to show the judge that he didn't have a clear view. Yet here he volunteers that this cross-examination did not help the defendants in trying to show that this eyewitness didn't have a clear view. He said he had a clear view.
What would you say to the argument that how officers, trained professionals, observe an incident is radically different than a civilian observing an instance, and where one might see a threat, one might not see a threat?
Well, I think the issue of threat is perception. But I also think what's there to be seen is what's seen. And in this case, once again, you have the video, this eyewitness, the police officer saying that the statement that she allegedly made was never made by her, Fontaine. There's enough evidence here for a conviction.
In your opinion, Mr. Rubenstein, do you believe that they tried to cover this up in the sense of we're going to justify this shooting? They got together and said, we're going to make Jason Van Dyke, this was justified. Or was it really an instance of they didn't do a thorough enough job and said, we're just going to take people's words for it, we're going to take what Van Dyke said? Or do you really believe that they came together and said, we're going to cover up the details of it? Because the counter-argument to that is, why didn't they destroy the videotape. I mean, that videotape that we keep playing was in March's custody for a while. Nothing happened to it.
Well, that might have created more problems for the police officer who destroyed it. We don't know for sure whether, in fact, this was a attempt to cover up by these police officers, if they, in fact, spoke together in a conspiracy. But it looks like the evidence is pointing to that at some point that's what happened here.
And we know the state is going to try to call one more witness to see if some crucial emails will be allowed into evidence. We're waiting for the judge's ruling on that tomorrow, and the trial will begin back up tomorrow afternoon. Let's take a quick break. When we come back, we'll have more of Jose Torres. All right, things got a little testy there. I'm back here with Sanford Rubenstein. Let's break it down first. First part that was interesting is when he goes, well, you didn't call 911. You really thought that there was something going on? You were bold enough to say to your wife, the police department's lying, yet you didn't report anything. Seems strange, no?
Look, that might have an effect with the jury, but with a judge, I'm not so sure. This witness appears to me to be an honest witness who is telling the truth. He has no reason to lie. Yeah, the defense lawyers are trying to make some hay out of the fact he didn't call 911. Doesn't change the fact he had a clear view of what happened and testified under oath what he saw happen.
But saying that I gave the police department the benefit of the doubt when I also thought that they were lying, something doesn't seem right there, no?
Look, on cross-examination, a lot of things come out that may be problematic. But I think the thrust, the guts of this witness's testimony is valid, and he can put these defendants in jail.
Now, here's the thing. He was saying how he didn't observe Laquan McDonald lunging. He didn't appear to be this attacker. But yet, in his previous statement, he said that Laquan McDonald maybe was getting back up, which is huge because that seemed to be one of the justifications for saying that he was an attacker that night, that was at one point used as a justification for why Jason Van Dyke fired so many bullets at him. So the idea that at one point he thought he saw him getting up.
Look, the fact of the matter is the jury, based in part on this witness's testimony, convicted the police officer of murder. This trial is not about the underlying case, whether the police officer was guilty or not guilty. This trial is about whether these officers attempted to cover that up. In that regard, I think his testimony as to what happened verifies the other testimony that's been brought forth by the prosecutors and gives this judge sound ground for a conviction.
But it seems like this trial is so much a recap of what happened in Van Dyke, trying to say, was this a justifiable shooting? Was it a homicide? Was there an aggravated assault? What was perception? I mean, I see so many common elements between this trial and Van Dyke.
And that's really not the issue here. The issue here really is that these police officers attempt to cover up what happened and falsely filed police reports with facts that were not true. That's the guts of this case, and I think the judge will see that.
Everybody was watching Van Dyke's trial. Hopefully they were all watching here on Law and Crime, but everybody was waiting for the verdict, and we all know everybody in Chicago was waiting in particular. What does this whole saga mean to the nation? I mean, there's one thing to question a police shooting, but now to say we're going to involve other people from the police department, we're going to examine all these conversations and see if there was a cover-up, what does that mean to you?
I would suggest that this trial has an impact not only on the lives of those who are involved, but also for the nation, because the issue of police officers filing false reports, attempting to cover up actions of fellow police officers is a real issue in this country. And when those who have done this are found guilty of it, hopefully it will prevent others from doing exactly the same thing.
Is the justification, the rationale behind why they do this, and again, they're still on trial for this, but in the instances you've seen, is it race motivated? Is it we're just going to protect our brother officer? It doesn't matter who the victim is. What motivates officers to engage in this conduct?
I would suggest it's something called the blue wall of silence. It's almost like a mafia in a way, where you're going to protect your brother officers and you're not going to testify against them, and you're going to attempt, when you can, to cover up what may have happened. This case has an impact on how the nation perceives the police. And we need the police. We need the police, and we need the police reports to be truthful. And when the police do something that's criminal, they need to be held accountable. And when police officers attempt to cover that up, they need to be held accountable as well to prevent that from happening again.
It's definitely shedding a light on the Chicago Police Department, as you said, on law enforcement across this country, but there's still a long way to go in this trial. We're still waiting to see what the defense will do and whether or not those really important emails will be allowed into evidence. So, Mr. Rubenstein, thank you for coming on with me. You're going to stick around. I'm signing off, but Bob Bianchi is coming in, and he's going to guide you through more of the testimony and critical moments from this case, and he also has a very special segment that he's going to introduce for you right after this break. So, as always, stay tuned here on Law and Crime.